This is part two of the lecture regarding chapter 11 of the textbook. And in this lecture, I want to highlight some of the matters that are included in the textbook in chapter 11. Certainly not all of them, but again, highlight certain things. The chapter is by and large based on the fact pattern that's set forth on page 300 of the textbook under a business organization. And it talks about four friends that are getting together to start a business, and it's going to be a bakery. And what it does in looking at these four different peoples, it points out that each one of them brings different things to the table and has various strengths and weaknesses regarding the potential business. And it forces us to think about when we're forming businesses, how control of the businesses should be allocated and ownership interests in the business. So again, just to highlight, we have Alice, who's 30 years old. She's the creative force behind the bakery. She's the only person amongst the group of friends that has any baking experience with the recipes. She's a single parent with two children, but only has $5,000 in savings and really can't put any money into the business. So it's her ideas that are going to get the business off the ground, but she doesn't have the wherewithal to do it. We have Betty, who's 62 years old. She's a retired teacher. She can put in up to $100,000 in the business, but doesn't want to have anything to do with the running of the business. So we can look at her as a silent investor in the business. Claire is 20 years old, has a building that's worth $125,000 that she could contribute to the business. Again, Claire, like Betty, doesn't want to have anything to do with the running of the business. And finally, we have poor old Dan. Dan's 25 years old, kind of gets by doing odd jobs for a landscaping company. He thinks he can be a great salesman and a manager, and is willing to contribute half of his total savings of $10,000. So again, you look at what Dan is willing to bring to the table. So the question that comes to us is what kind of business will best suit them? And it really depends upon your perspective, frankly, who you would be representing. And one of the issues that presents is when lawyers are asked to form business entities for clients. Oftentimes you'd have four people like this come to them asking the lawyer to form the business, and the lawyer is forced to are required to disclose that, hey, you'll have radically different interests in this. And if I'm going to represent all four of you, each one of you should probably have your own separate lawyers to make sure that you're protecting yourself. So the different type of businesses that are discussed in Chapter 11 are a sole proprietorship, a partnership, a corporation, and a limited liability company. And again, clients that come in to the lawyers often don't have any idea of what kind of business that they might want to perform. So we have a good chart on page 301, figure 11.1, that compares the basic types of business entities. And again, I commend this to you. It's a great summary of some of the different entities. Sole proprietorship obviously would not work for this group, but a sole proprietorship is important for us to understand the characteristics of a sole proprietorship. It's one person, hence the word sole. The main disadvantage of a sole proprietorship is that the owner, the sole proprietor, their personal assets can be reached by creditors of the business. So if the business goes down, the creditors of that business would be able to sue the sole proprietor, get a judgment against him, and go against the sole proprietor's assets. Advantages of sole proprietorship are that, very little regulation, really no filings other than a fictitious business name statement. The income and the expenses of the business are passed through. on the tax return of the sole proprietor. And again, very, very easy to form and operate. A partnership, on the other hand, is an association of two or more people. A general partnership suffers from the same disadvantages of a sole proprietor, in that in a general partnership, the personal assets of the general partners can be reached by creditors of the business to satisfy any debts that they may have. The partnership is not a tax-paying entity. What this means is that a partnership does file tax returns, but it doesn't pay taxes. All of the taxes that are associated with the income of the partnership are passed through to the partners. And so we call them conduits, flow-through entities. Normally, with a partnership, we would have a written partnership agreement that details the obligations of the various partners, but it's not required. You can have an oral partnership agreement. Finally, you should understand that if you do have a general partnership or a partnership, any type of partnership, really, the partners have fiduciary obligations to one another, meaning they can't, they have the obligations to bring partnership business opportunities to the partnership, and can't unfairly compete. So an example I like to give is if you and I formed a partnership for the purpose of investing in strip malls, rehabilitating them and selling them. We had a partnership that where we agreed to do that. And I found out about a great opportunity, say it was in Hesperia. And I just said, hey, I can make a boatload of money on this on this deal. I'm not going to tell my partner about it. That would be violating my fiduciary duties to the partnership. I have a duty to bring that business opportunity to the partnership. The next type of business organization that's discussed is a corporation. And a corporation can have one or more owners. Again, we can have corporations whose stock is owned by just one person, but normally it's more than one person. The owners of a corporation, we call them shareholders. They own stock of the corporation. So the corporation is a separate legal entity. Unlike a partnership, it does pay taxes. And one of the advantages of a corporation is that the owners of a corporation are not personally responsible for the debts. So to use an example, Bed Bath & Beyond, a corporation that's having lots of troubles, if it were to go out of business and have judgments against it for unpaid rent, unpaid suppliers, the shareholders of Bed Bath & Beyond, the owners of the corporation, are not responsible for the debts of Bed Bath & Beyond. The corporation, a legal entity in and of itself, is responsible for the debts. So again, corporations are owned by the shareholders. They're governed by the board of directors and ultimately run by the officers. So again, read the discussion of a corporation in the textbook. So the last type of business entity that I want to discuss is a limited liability company, an LLC. An LLC is kind of a hybrid between a corporation and a partnership. It has the advantage of a corporation in that the owners of the LLC, which we call members, are not personally responsible for the debts of the business. On the other hand, an LLC does pass through its profits and losses to its members, so it doesn't pay income taxes in and of itself. All of these things are passed through to the members. So again, coming back to our four individuals, if we're asked to represent them, there's an obvious conflict of interest between the four. And really, it basically comes down to how should the business be structured? Should the owner of the property, instead of being an owner of the business, simply be its landlord and collect rent? If they do contribute the property to the business, how do we value the property? That's going to affect their percentage ownership in the business. How do we value the contributions of the creative force behind the business? Alice, she has the recipes and the know-how. How do we value what she's bringing to the business? And again, compare that to the others. The person with $100,000, should she simply lend the money to the business and be a creditor, or should she invest that money and be an owner? And finally, we have the down and out Dan, who really doesn't bring anything to the business other than the ability to work and the willingness to work. How do we value his contributions to the business? And so it should be evident that probably forming an equal partnership or a corporation having equal shares probably isn't the best idea, and certainly would not be fair to everyone concerned. So again, lawyers and paralegals struggle with these issues when they're forming business entities. Beginning at page 304 of the textbook, there's a discussion of employment and labor law. And again, as noted, it's a broad area of law, and I'm going to quote, it deals with wages, hours, unlawful termination, child labor, workplace safety, workplace injuries and diseases, family and related leave, pension and benefit plans, rights to unionize, regulations regarding unions, sexual harassment and discrimination, etc. So again, this illustrates the broad scope of labor and employment law. The text emphasized the general rule that most employment is on an at-will basis, and that means that the employee can leave at any time for no reason. And on the other hand, the employer can terminate an employee at any time. And the restrictions that have developed on at-will employment is that it's okay to fire somebody for no reason, but it's not okay to fire somebody for a bad reason. And a bad reason are reflected in public policy. So for instance, if it was racial discrimination or sexual discrimination, these are bad reasons to fire someone. So it'd be illegal. That's an exception to the at-will rule. The text also points out a couple of different important acts that we have the very important Age Discrimination and Employment Act. That's the ADEA, and that prohibits discrimination against individuals 40 years old and older. So again, it's kind of a mind-boggling to consider somebody being 40 as elderly, but they are covered by the ADEA. Another very, very important law is the Americans with Disabilities Act, the ADA, which prohibits employers from discriminating against those with physical or other impairments, but are otherwise qualified to perform a job with reasonable accommodation. So we have a lot of litigation in the employer-employee area about the ADA. There's also a lot of litigation about the ADA as far as public access to facilities. So you have lawyers that specialize in ADA matters and suing business owners because of failure to make reasonable accommodations to people. The next area of law that I want to briefly discuss is covered in the textbook is debt collection and bankruptcy. Bankruptcy law, like employment and labor law, is a separate class that we teach at Cerritos in the paralegal department. Going back to the business formation, we also have a class in corporations, which deals with business organizations, and of course a class in employment law. The text emphasizes, and I want to emphasize as well, that the bankruptcy and debt collection practice it involves substantial involvement of paralegals dealing with preparation of legal documents and with client contact. You should be aware of the basic types of bankruptcy proceedings in an introduction to law class. The three most common bankruptcy proceedings that we encountered are Chapter 7 bankruptcy cases. These are liquidation cases where individuals or businesses file bankruptcy, essentially turn over all non-exempt assets, which are then sold, and creditors are paid from them. And the ultimate goal of a Chapter 7 bankruptcy practice or proceeding is for if it's an individual, to have a discharge entered. And a discharge releases people from legal liability for most types of debts. There are some debts that are not dischargeable in bankruptcy. These include things like child support, spousal support, certain tax obligations, debts incurred through fraud, things of that nature. But again, the idea behind a Chapter 7 proceeding is kind of a fresh start, throw out the bad, move forward with the good. But the other two most common bankruptcy proceedings are reorganization proceedings. Chapter 13 is a reorganization for individuals, that is for people, living and breathing people with regular income. There's a limitation on Chapter 13. The current debt limitation is your debts have to be under $2,750,000 in order to qualify for Chapter 13. Chapter 13 can be used, again, to reorganize your financial affairs. So if you fall behind on a mortgage or a car loan or taxes, support, things like that, Chapter 13 is a way to allow people to catch up and become current while at the same time making regular payments. Chapter 11 is another type of reorganization case, both for individuals and businesses. Again, the goal of Chapter 11 is to reorganize the financial affairs of the individual or business to allow them to continue forward. So again, this is a very important area of law, and one in which we teach here at Cerritos. The next area that I want to highlight that's covered in the textbook is, again, another area class that's taught at Cerritos is immigration law. Again, there's a discussion of immigration law at page 309 of the textbook. I commend that to you. Estate planning and probate is discussed beginning at page 314. Again, as the text points out, it involves lawyers helping clients plan how they want to transfer their property to their surviving family, friends, charities, etc. The textbook talks about the differences in dying with a will, which we call testate, T-E-S-T-A-T-E, and without a will, intestate. Many people have the mistaken impression that if you die without a will, all your property goes to the state. That's absolutely not true. And as the text points out, that if somebody dies without a will, all that means is that their property will be distributed according to the laws of the state. And typically it's to relatives based upon the closest in degree of to the decedent, the person that died. Trusts, on the other hand, are designed to avoid probate. and to provide other protection for both the person that creates the trust and also the beneficiaries. For instance, we can create a trust to benefit someone that suffers from disability, and create a trust that, if done properly, could be used to supplement public benefits that might be available to the person with disability, and also to make sure that they don't spend the money, that their creditors can't access the money. Again, the trust law is a very complex but a very important area of law. The text talks about the concept of a living will, and in California we use the term Advanced Healthcare Directive. These type of documents allow a person to make decisions about the type of healthcare that they'd like to receive at the end of their life. Again, they do much more than that, but we think of them primarily as a way to instruct our doctors and caregivers of the nature of healthcare we'd want to receive towards the end of our life, when we're no longer in a position to communicate that. If we're in a coma, for instance, what kind of measures do we want undertaken to take care of us? So again, very, very important. Finally, there's a discussion of probate process. And again, as I mentioned in the first lecture, probate is actually a court-supervised proceeding to administer the estates of decedents. Again, there are other areas of law that are discussed in the textbook. It's important that you do read and understand that. I didn't cover, for instance, in this lecture, the area of administrative law or property law, including real estate and intellectual property. So make sure that you do review those. And again, one other thing just to that I want to emphasize, and one of the nice things about this textbook is the articles that are contained in the areas called paralegal profiles, and kind of give you an idea of what paralegals do. So again, to summarize, make sure that you do read and understand Chapter 11 of the textbook. Be familiar with the concepts set forth in Chapter 11. And again, I hope you enjoyed this introduction.